Welcome to Eye on Crypto, where we delve into the crypto flow and share the insights you need to know.
Did the SEC bite off more than they could chew with XRP in their battle against crypto? Renowned writer and Forbes contributor Sam Lyman believes the U.S. Securities and Exchange Commission (SEC) may have underestimated the challenges it would face in its legal battle against Ripple. Sam expressed his thoughts on Sunday, May 21, through a tweet stating that he did indeed believe the SEC may have bitten off more than it can chew in its campaign against XRP. This statement comes after he recently published an article on Forbes discussing how the lawsuit's ripple effects could benefit not only the XRP community but also Coinbase and the entire industry. Led by Chair Gary Gensler, the SEC's efforts to categorize digital assets as securities have faced unexpected opposition due to its past statements and internal documents, which have now been made public following a recent court ruling. In his article, Sam suggested that the release of the Hinman documents, which the SEC wanted to keep hidden, could strengthen Ripple's case by revealing that even SEC staff members believed XRP should not be considered a security. These documents are likely to show disagreements among the agency's own employees regarding which cryptocurrencies should be classified as securities and why. By doing so, they are likely to support Ripple's case, Sam wrote. Furthermore, Sam pointed out that if the Hinman documents provide additional evidence of internal communications contradicting the SEC's current stance on regulating digital assets, it could pose significant obstacles for the agency's case and reputation. It would also reinforce Ripple's argument that the lack of regulatory clarity hindered their understanding of legal boundaries in the industry. Lyman also pointed out that the implications of the Hinman documents go beyond the XRP lawsuit and could have an impact on Coinbase's position in future legal battles against the SEC. According to him, the SEC's approval of Coinbase's IPO, despite listing assets similar to XRP without a broker-dealer license, raises doubts about the agency's stance. In this regard, he highlighted that the documents in question could provide insights into whether the SEC considered these assets as unregistered securities or if they overlooked investor protection. Meanwhile, John Bitten, a vocal lawyer supporting Ripple, agreed with Lyman's perspectives, stating that the lawsuit was not solely focused on enforcing U.S. securities laws but seemed to have other hidden motives. The lawsuit was not only about enforcing U.S. securities laws. If that were the case, it would have been limited to specific sales made by Ripple and would have been settled by now. The lawsuit was used as a weapon with bad intentions, tweeted Bitten. The lawyer also commended the unexpected support Ripple received from the XRP community, expressing confidence in their collective efforts leading to a favorable outcome. As the XRP lawsuit progresses and the Hinman documents come to light, the cryptocurrency industry eagerly anticipates the potential results that could shape the future regulatory landscape. Coinbase, the largest cryptocurrency exchange in America, has voiced its support for Ripple in the midst of the ongoing legal battle with the Securities and Exchange Commission, which is expected to reach its conclusion soon in 2023. Backing Ripple, Coinbase takes a stand. In a series of tweets on October 31, Paul Grewal, the chief legal officer of Coinbase, announced that the exchange had sought permission from U.S. District Judge Annalisa Torres to submit an amicus brief. Commonly known as a «friend of the court» brief, in the SEC's enforcement action against Ripple. It's been 2 years since the SEC filed a lawsuit against Ripple, its former CEO Chris Larsen, and its current CEO Bradley Garlinghouse, alleging that they had raised $1.3 billion through an unregistered securities offering of the XRP cryptocurrency. This high-profile case has undergone numerous procedural motions, and recently, both parties filed their motions for summary judgment. Asserting its unique perspective on the issues in this matter, and highlighting the lack of a regulatory framework governing digital assets, Coinbase stated that it believes entities like Ripple should be allowed to pursue fair notice defenses in cases where they face unexpected enforcement actions such as this. The exchange further argued that this case serves as a classic example of the significance of fair notice. Coinbase will join forces with the crypto industry lobbying group, the Blockchain Association, the crypto payments app Spend the Bits, and the non-profit organization Investor Choice Advocates Network. Together, they aim to strengthen Ripple's defense against the SEC. This filing follows closely after attorney John Bitten from Rhode Island requested permission from the court overseeing the case to file an amicus brief on behalf of the decentralized XRP community. As of now, XRP's price has risen by 7.2% in the past 7 days and is currently trading at 45 cents. It holds the 6th position among the largest cryptocurrencies in the market. Alongside the recent positive developments for Ripple, there is speculation that the SEC is likely to lose the lawsuit, which could potentially provide the necessary momentum for XRP to skyrocket. Garlinghouse told his followers towards the end of last year not to believe the agency when it claims to care about disclosure, transparency, and clarity. When the truth eventually comes out, the shamefulness of their behavior here will shock you, he summarized. The U.S. District Court for the Southern District of New York is yet to deliver a judgment on whether Ripple's XRP can be considered a security. In the meantime, the attorney representing XRP holders in the crucial Ripple lawsuit made a huge claim on the nature of the XRP token based on the SEC staff submission. Attorney John Bitten, amicus curiae in the XRP lawsuit, highlighted a footnote from Ripple's opposition and reply briefs submitted in the court. It stated that, there are reasonable grounds to conclude that XRP does not satisfy all elements of the Howey analysis and is therefore not a security for purposes of the federal securities law. While Exhibit 230 also stated that it is, more likely than not, that XRP will not be considered a security and thus it should not be subject to regulatory oversight by the US SEC. It is important to note that mentioned statement is from Exhibit 220, which is a part of the SEC emails. However, this raises a vital concern here. Why did the Commission allege charges against the Ripple executives when its staff analyzed that XRP is not a security in nature? After both the SEC and Ripple called for an immediate ruling on the lawsuit based on available evidence, without taking the case to trial in October last year in order to bring an end to the long-standing case, we saw the price of XRP jump by over 40%. As we get even closer to what should be the final days of the trial, could XRP be about to skyrocket again? XRP has seen a 35% increase since the beginning of the year with an average price of 42 cents in 2023. We believe a win or settlement for Ripple this year could easily boost the price of XRP to around 60 cents to 70 cents in 2023. And position XRP for a $7 price or higher for the next bull run. This is not financial advice and you should always do your own further research before investing into anything. Check out our other videos for more updates and why a settlement could be even more explosive for the price of XRP. Thanks for watching. Don't forget to leave a like if you're an XRP holder. Keep your eye on crypto, and we will see you on the next one.